Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
The outset, it is required to be noted that before the reference court as well as before the High Court, the only evidence produced on record was the sale deed, which was rejected from being considered stop. Hence, as such, there was no other evidence material on record to arrive at a fair market value for the acquired land stop. Therefore, before the High Court, the appellant filed an application under Order 41, Rule 27 CPC for additional evidence to bring on record the sale deeds and certified copy of the judgment and award passed by the reference court, which according to the appellant would have a direct bearing on the determination of the fair market value of the acquired land. The High Court has rejected the said application by observing that the application does not satisfy the requirement of Order 41 Rule 27 read with Section 96 of the CPC stop. The High Court has also observed that the appellant has failed to establish that notwithstanding exercise of due diligence, such additional evidence was not within his knowledge and could not, after exercise of due diligence, be produced before the courts below stop. However, the High Court, while considering the application for additional evidence, has not appreciated the fact that the documents which were sought to be produced as additional evidence might have a bearing on which was rejected by the courts below. No further evidence was on record to determine the fair market value of the acquired land stop. It was a case of awarding of fair compensation to the landowner whose land has been acquired for public purpose stop. It cannot be disputed that the claimant whose land is acquired is entitled to the fair market value of his land stop. It is true that the general principle is that the appellate court could not travel outside the record of the lower court and cannot take any evidence in appeal stop. However, as an exception, Order 41 Rule 27 CPC enables the appellate court to take additional evidence in exceptional circumstances stop. It may also be true that the appellate court may permit additional evidence if the conditions laid down in this rule are found to exist and the parties are not entitled as of right to the admission of such evidence stop. However, at the same time, where the additional evidence sought to be adduced removes the cloud of doubt over the case and the evidence has a direct and important bearing on the main issue in the suit, and interest of justice clearly renders it imperative that it may be allowed to be permitted on record. Such application may be allowed stop. Even one of the circumstances in which the production of additional evidence under Order 41 Rule 27 CPC by the appellate court is to be considered is whether or not the appellate court requires the additional evidence so as to enable it to pronouncement, judgment, or for any other substantial cause of like nature evidence sought to be adduced to enable it to pronounce stop.